40360. All right, so we started our probate court 9 o'clock call with Gordon Garti file. We have the names of our participants, please.
Good morning, Your Honor. Isaac Sneed, petitioner.
Michael McFarland, attorney, guardian ad litem.
Okay. All right, are you expecting anyone else to join us?
No, Your Honor.
All right, Mr. Sneed, it looks like this is your request to approve the first annual accounting.
It is, Your Honor. I succeeded Clark Baldwin for Mr. Garti, who was his conservator for many years. So this is my first account on behalf of Mr. Garti. It has been served on all interested parties. I would ask the court to approve the account today. Thank you.
So it looks, Mr. McFarland, it does look like you have some paper on it. Any comments that you wanted to make?
Yes, Gordon would like to purchase a vehicle. He has a history of giving away things, including a vehicle that he had in the past. Right now, when you take a look at his allowances, it's about $300 a week, even though his expenses are paid. It's not clear to me that he's spending everything for his own. He may be supporting somebody else, which is the reason he has a conservatorship. I would like to see, and I told Gordon this, if I was to support him getting a car down the road, I would like to see him provide receipts for where the $300 per week is going. So I know he's not supporting his brother or somebody else. As it's one of the principal reasons of his conservatorship. I've been on this a long time. So just a thought, I would like to see some receipts for his allowance, if I might.
Mr. Steve.
I have no issue with that, Your Honor. Mr. McFarland and I spoke about that. And Mr. Garti is willing to provide those. He does have a mode of transportation. It's just the message that was conveyed to me by Clark Baldwin back in the day was that Mr. Garti will adamantly ask for a car, but don't purchase a vehicle. So I've sort of stood by Clark's advice since then, but again, we're not ruling that out ultimately. Thank you.
Well. Is the $300 allowance something that's been in place historically?
I believe so.
It has, Your Honor.
Well, Mr. McFarland, do you think that that is a concern that can be addressed during the next accounting period?
I do, yeah, and that's why I just asked to have some receipts to demonstrate where those funds are going. Plus, it also, I anticipate there may be a petition to purchase a car or consideration, so I would like to see that to know that he is properly spending his allowance, not giving it away as he should.
I just want to clarify that this is not an objection to the current petition.
It is not, Your Honor. You just asked for comments.
Very good. All right. Well, the court finds all interested parties were given notice for purposes of the hearing requesting approval in the first annual accounting. I do find that it appears to be correct and ought to be allowed. Mr. McFarland has expressed his preference to review some of those items a little more closely in the next accounting period, and we'll count on Mr. Sneed to follow up with that. Otherwise, the order does reflect the first annual accounting is allowed, including any flight fees and costs set forth as requested. Unless there's any questions, that's all for today.
Oh, thank you.
Thank you, Your Honor.
Okay. This is a matter of Celeste Scott, file 42134. The court's been asked to approve the 22nd, 23rd, and 24th annual accountings in this case. May I have the names of our participants, please?
Grace Arnold, and I am the conservator and guardian for Celeste Scott.
Very good. Good morning, Ms. Garno. How are you?
I'm good, Your Honor. How are you this morning?
Doing well, thank you. All right, I have seen the accountings. Are there any comments that you'd like to make about those amounts or any of the expenditures that have come through in the past year or few years, I should say?
No, Your Honor, they've been fairly standard. Celeste is doing well, and she now has a housemate, so she's pretty happy these days with the situation. The fees that I have billed, Your Honor, essentially I bill at really just $200 a month. Most months that's at least an hour and a half worth of time. And there are some months where it's 15 to 20 hours of time, depending on what might be happening. Probably average is really 3 to 4. It takes me about 45 minutes even just to get to her to visit her, and I try and visit her about once a month.
Very good. I appreciate that. I will ask you to itemize it a little better in the future. There are some, I'm looking at the invoice for fiduciary services. The higher courts have asked us to look carefully at the billable hourly rate for services and distinguish between legal services and services as conservative or guardian. So unless there's something technical or legal that's required, I would need to see you itemizing your conservatorship and guardianship fees at the usual rate, which I think in our court is around $35 an hour, which sounds, frankly, given the amount of time that you're spending, probably about where we're at with the $200 per month. But if you could just clarify that a little better in the future, I think that would be useful to us in the event that the file be more highly scrutinized. But I do appreciate your comments in your notice explaining what your services are, as well as your comments on the record. And I would note that it does not reflect mileage either, which you would be entitled to as a guardian. So I do find the fees to be reasonable, but I would just ask you to delineate them a little more specifically in the future.
Of course. All right.
I'm sorry?
I will, of course.
Oh, okay. Thank you. All right. Anything else before I make my ruling?
I don't have anything.
Very good. The court finds all interested parties have been given notice for purposes of the hearing on today's petition to allow the 22nd, 23rd, and 24th annual accountings. The accounting does appear to be correct and ought to be allowed, including those fees and costs, as the court has already ruled. So the order reflects the approval of those accountings, including those fees and costs. Thank you again to Ms. Garneau, who is, I'll just say for the record, exceeding the number of times she needs to be visiting as well, monthly versus quarterly, and I appreciate that as well.
Thank you, Judge.
You're welcome. That's all for this morning.
Thank you.
This is a matter of Christine Benningfield, file 52276.
All right, this is the petition to allow the first annual accounting. Do we have Ms. Cassidy Benningfield with us? I see someone logged in under Cassidy Benningfield. Are you available to us? Ms. Underwood, are you here on this one?
I am, Your Honor, and that may be Miss Christine in the top right, but I'm not certain.
Yes, Christina is present.
Thank you.
Okay. Is Cassidy Benningfield here? She's logged in, but she doesn't appear to be responding.
She has a child with some severe medical issues.
Okay. I see also Mr. McFarland has left us a letter with some concerns as he reviewed it. Deputy James, would you, oh, there he is. Mr. McFarland, we're here on Cassidy Benningfield's accounting on Christine Benningfield.
Yeah, Your Honor, unfortunately, my database appears to be down. Our office is having problems with our database. I'm trying to pull it up. Give me one moment. I'll see if it has recovered.
You have expressed a concern as guardian ad litem that you wanted to review some receipts.
Your Honor, we did review those receipts earlier this week. They were in a large manila folder and they were sort of tucked in between.
Yes, Your Honor, I submit that to Dawn Fisher yesterday. She just returned from vacation today. I did sign the consent waiver. I reviewed the receipts. Thank you for refreshing my memory. And so, yes, I have no objection to the accounting.
Great. Yes, I thought maybe we could jog your memory. It's only June 4th was dating your letter, so. Very good. Well, I would take some verification of this from your client and your oath, but I think she's having a little trouble here this morning. Oh, I have a Cassidy's iPhone in the waiting, so maybe this will.
Hi, sorry about that. My computer wouldn't work.
One moment. Okay, there we go. So I'm getting a pretty big echo. Or maybe not anymore. Can you hear me okay?
I can hear you okay. Can you hear me okay?
Yes, very well,
Okay,
very
so
good.
I apologize about that.
Wait. Okay, appreciate the apology. Deputy Anderson, do you swear in Ms. Cassidy Benningfield?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Ms. Underwood, would you like to do the voir dire? Or would you like me to?
Sure, I can do it. Cassidy, can you hear me okay?
Yes.
Did you recently hire me to help you prepare the first annual account for Christine Benningfield?
Yes.
Okay, and the numbers, the amounts for each of the schedules on the accounting, are those complete and accurate?
Yes.
Ms. Benningfield's currently in a skilled nursing facility, is that correct?
Yes.
And that's where the majority of her income is going annually?
Yes.
There is a miscellaneous category of approximately $1,500. Can you just clarify what those funds were spent on? The majority of the receipts were from Walmart and one from, I believe, Dollar General and one from Amazon.
Mainly snacks for her for at the skilled nursing home, and then I think it's like blankets and stuff like that for her in the nursing home.
Okay, so you can confirm that those are all for her necessities for her while in the care of the facility?
Yes.
Okay. I don't have any further questions. Thank you.
Mr. McDonald?
No questions, Your Honor.
All right. Thank you, Ms. Cassidy Benningfield. How often are you able to visit with Ms. Christine?
I try to at least once a month. I do have a son that does have a lot of medical issues, so sometimes I am in and out of town, but mainly once a month.
All right. And you're available to her, obviously, or any of the staff at the place where she's residing in the event that something happens they need your opinion on?
Yes.
Any follow-up questions?
No, Your Honor, thank you.
Okay, well, thank you, Ms. Benningfield, for keeping those receipts so that we can verify those expenses. That doesn't always happen effectively, and thank you for visiting regularly as well. The court finds all interested parties were given notice for the hearing on the first annual accounting. It does appear to be correct and not to be allowed, which is what the order will reflect. Unless there's any other questions, that's all for today. Thank you for coming.
Thank you, Judge.
We're all set.
Thanks for your time. I seem to be back online, Your Honor. So.
Oh, that's good.
This is a matter of the estate of Carol Sue Arnold, file 53222.
All right, the court's been asked to open this estate under formal proceedings. May I have the names of our participants, please?
George Shea on behalf of the estate. Filing to request reappointment as personal representative. And Your Honor, we were asking for informal administration of this. We were asked to file a petition because the will that was submitted was her will dated April 7th, 2016, but the attestation page at the back of the will, the fourth page, was from a prior will dated April 10th, 2013. So obviously that attestation is a nullity. It is an error to error part of my office to attach that. So I guess that leaves us with the will without the attestation page, which is why we have to have the petition. But the will appoints myself as personal representative. Carol Arnold had two sons, Todd LaPrairie and Timothy LaPrairie. Both of them have been served by first class mail on June 24th. And I asked the court to appoint me as personal representative.
All right, is it your intention in the event that litigation is required to secure other legal counsel on behalf of the estate, or do
Yes.
you intend to? Okay.
Yeah.
And I see the will mentions a number of monetary distributions. Are there other assets that will need to be distributed?
No, her house has been sold, so everything is liquid at this point.
Approximately how much is in the proposed estate?
Well, I haven't refreshed my mind on that, but I expect it's about $1 million.
Have you considered securing a bond for the duration of your service in the event that anything were to happen to compromise those funds?
I haven't, I could, of course, if necessary, but I did her estate plan, and we do have a trust, and we put everything into the trust. But her son, Tim, is the trustee, and he's been serving as trustee for about 3 years. As Carol was in a nursing home and not mentally competent to manage her own affairs. And one of her accounts, I'm sorry, Tim transferred from one financial institution to Vanguard. And in doing so, originally it was supposed to be a pay on death or transfer on death to the trust. Because he transferred it, he didn't make sure that happened. So that's really the only asset of the estate. So actually, I apologize. Her gross estate is about $1 million. I believe it's about $400,000 in that one account that's really subject to this probate. So my only activity here will be to collect that and move it into the trust. And then I'll be finished.
Thank you. That helps me. That helps a lot clarify what's happening here. All right. Anything else then before I make the ruling?
No, nothing, Your Honor.
Very good. Well, the court finds all interested parties were given notice for purposes of the hearing today. I do find that the information in the file does support that Ms. Carol Sue Arnold passed away February 16th, 2024, a resident of Lenawee County, making venue appropriate in this state. The determination of heirs is uncontested, as is the request to probate the estate under the will previously indicated and discussed. Regardless of the clerical error, as explained by Mr. Shea. I do also find that Mr. Shea is suitable for appointment. He is named and has the priority as the named proposed personal representative. I do not find supervised administration or a bond is necessary at this time, given the anticipated singular transfer as described by Mr. Shea as well. It is the order of the court. The petition is granted. The will is valid, determined to be valid, admitted, and will govern the administration of the estate, which will be spearheaded by Mr. George Shea as personal representative, who again will serve without bond, and the decedent's heirs are properly also determined as part of today's court order. So I've signed the order. I am admitting the will and signing the letters of personal representative authority for Mr. Shea. Unless there's any questions, that's all for today.
Thank you very much, Your Honor. I'll be in contact with your clerk to get those letters.
Thank you. Please express my condolences to the family.
Thank you very much, Your Honor. Very kind.
Yes, you're welcome to contact the clerk's office.
Thank you.
This is in the matter of the estate of Rowana White, file 53256.
All right, the court's also been asked to open the state in this manner. May I have the names of our participants on this file?
Brian Fry, attorney for Rhonda Auer, the petitioner, Your Honor.
Good morning, Your Honor. David Grant appearing on behalf of Regina Sherman, who's also appearing via Zoom.
Okay, Ms. Sherman, could you introduce yourself?
Hello, I'm Regina Sherman.
Thank you. And then Mr. Fry, if you can either introduce or ask your client to introduce yourself.
Yes, my client is sitting next to me.
My name is Rhonda Auer.
Thank you. Welcome. A-U-E-R.
Yes, ma'am.
Rodney White.
Welcome. Okay, so the only proposed heir we're missing is Mr. Brady White. Welcome, everyone. Okay, Mr. Fry, this is your request.
Yes, Your Honor, we are.
I apologize, Your Honor. Before we take testimony, I think we're going to have to set this for a contested hearing regarding who the personal representative is going to be.
Okay, Mr. Gren, this is technically Mr. Fry's petition, so I'm going to let him speak first, and then I'll give you an opportunity.
I apologize.
Thank you, Your Honor. Your Honor, we did file this petition requesting the court to name a personal representative to this estate. This is my client's mother who passed away. The three people who are here today we're all children. Mr. Brady White was a grandchild because his parent had passed away previously. My client is willing and able to serve as a personal representative in this case. We did file this. I haven't had any competing filings that's been served on me at this point. We ran the ad in the newspaper announcing the hearing today, as well as allowing any creditors to come forward. None have so yet, but they do have a little bit more time if they wish to do that. My client is an appropriate person. There was no personal representative in this case. She's able to handle those duties and willing to. There was no will in this case. My client's mother did die intestate as far as we've been able to determine. So this is a intestate proceeding. The family, in this case, there's some age gaps as well as other issues that my client is concerned about that requires her to be able to monitor what's happening. So there's a fair distribution in this case, which my client is agreeable to make. She just wants this to be fair, follow the law, and be concluded so everyone can move on after dealing with this law. So we are asking that personal representative be appointed as my client, Your Honor. If this needs to be formal proceedings, then that is fine. We're willing to do it informally as well, but if everyone would feel more comfortable with formal proceedings, then we're willing to do that. But we are, again, able, willing, and ready to get this estate administration going, Your Honor. Thank you.
What are the proposed assets of the estate?
There's a house, Your Honor. There's some accounts. We don't know how much are in those accounts at this point, but there is a house and there's something personal property in the house that'll have, some value. We're not talking, this isn't a huge estate.
Your client is living in another state?
Yes, Your Honor.
Will she be able to adequately administer the estate, clean out the house and all of those things given her distance?
Yes, Your Honor. She doesn't, she's not working, so she has the time to come up here and take care of this. So she's here today.
All right, Mr. Gren.
Thank you, Your Honor. I apologize for putting the cart in front of the horse. I would agree with, for the most part, everything Mr. Fry has indicated. My client is also ready, willing, and able to serve as personal representative. As this court is aware, many times in probate cases, there is mistrust and anxiety among beneficiaries of the estate. This case is no different than those cases. Along those particular lines, my client is objecting to the petitioner's appointment as sole personal representative. We have explored, I have broached the subject with Mr. Frey regarding appointing an independent personal representative who will simply follow the law. There are different issues involving identification and return of personal property to the estate that may have been taken by interested parties and that strictly relates to the minor child Brady, who is entitled to 1/4 of those items. The petitioner, as the court is aware, is from Tennessee. It's my understanding there's been a rather estranged relationship between her and her mother, which makes her ability to identify the personal property that was there for the benefit of the estate. At this juncture, it's the court's sound discretion on appointment of the personal representative. All parties have equal priority. The surviving son, and I apologize, I can't remember his name. Mr. White, Rodney White, we believe is currently in possession of the house. It's unknown whether or not, at this juncture, whether or not a will was done. I understand previously that Mr. White was believing that a will had been done, leaving the house to him. And there's just a lot of conflict among all the people. So I think the court has to rule who's going to be the personal representative, and it's going to require a hearing along those lines. At this juncture, we are not aware of a will. We do know that some preparatory work was done through UAW Legal Services regarding a will, but we don't know whether or not it was ever returned to UAW. We don't know if it was ever executed by the decedent. There's a lot of things that we don't know at this point regarding that testamentary document. I don't know. I know that my client isn't aware of the existence of a will. It's clear that Mr. Frey's client isn't aware of the existence of the will. Mr. White may have information regarding that. Nothing has been filed to date. And we're pretty convinced that the minor child, Brady White, isn't aware of a will because there's been limited or no contact between the grandson and his grandmother after his father died. Thank you.
All right. Mr. Grant, is there a reason you declined to file any kind of formal objection to the request or a competing petition for a personal representative on behalf of your client?
Well, Your Honor, I had filed an application with a notice of appointment, and I inquired with the court staff whether a formal objection was required or I could simply appear and request a formal hearing for that. And I was advised by the staff that I could make my presentation and make my request at today's hearing. But I was concerned about that, and I was going to send somebody there to file something until I was advised it wasn't necessary.
All right.
And I shared that, and I did share that with Mr. Fry.
Would you and your client be willing to submit to mediation on this issue and some of the other issues that you've raised today?
Absolutely, Your Honor.
Same question, Mr. Fry.
Yes, Your Honor.
Okay. Mr. White, mediation is essentially an opportunity for all of you to sit down, whether that's virtually, probably virtually, given the distances between everyone, and have sort of an independent person at the head of the table to allow everyone to talk about their concerns and to see if resolution can be reached as a group.
Yeah, I'd be fine with that.
All right. My inclination here, gentlemen, would be to give you an adjournment for approximately a month, to offer to you the services of our court-appointed mediator, Mr. Shadler, if you wish to use his services, to try to sit down for that mediation between now and when you come back, or if you would like to use a different mediator, you're welcome to do that. But I can offer to you the opportunity to use our mediator, at least for the first one. Any preference?
I'm fine with Mr. Shadler.
Okay.
That works for me.
Very good. All right. So I'll give you a month to do that. And if you need more time, just let us know and we can push it out. But I'll reset your hearing today, Mr. Fry, to Thursday, August 29th at 9 o'clock, assuming you're available.
Yes.
Mr. Grant, any conflict with that date and time?
No, Your Honor.
Very good. All right. So the order will reflect that the matter is being adjourned to allow you to utilize the mediation process to see if you can come to a resolution on some of the issues that were raised today. And we'll come back together on August 29th at 9 to see what you've been able to accomplish. I'm sorry for your loss.
Thank you.
That's all in this file for this morning.
Thank you, Your Honor.
You're welcome. Next, the Stansbury file.
This is in the matter of Richard Stansbury, file 46042.
This is a petition to approve the 14th, 15th, and 16th annual accounting submitted by Amber Scobie as a conservator.
Zowie, in need of checking.
Yes, Ms. Scobie, it's for Amber Scobie's group.
And we're still. What else in the hallway?
It looked like there were some issues getting these reports, at least one of these reports submitted timely. Have been submitted with supporting documents. And Scobie was and is the only interested party who would appear and was served. Accounting is on behalf of Richard Thomas Stansbury, who's a minor who's included a waiver as to his appearance on the petition to allow 14th, 15th, and 16th account hearing. And there is also a waiver by Ms. Amber Scobie for the same. It does appear that the petitions are supported by valid information verification from the banks as to the restricted accounts and the small amount of interest that's accumulating on an annual basis. Both interested parties have waived, so I will go ahead and enter the order approving those accounts that have been verified. All right, that's it on this one, Ms. And our last one.
In the matter of the trust of Zachary Welday, file 52662.
Right, the court's been asked to approve the first annual accounting in this file. We have the names of our participants, please.
Emily Robertson, appearing on behalf of petitioner Richard Welday.
And Richard Welday.
Welcome. Deputy Ames, would you swear in Mr. Welday?
Yes, I'm Richard Welday. I'm the trustee.
Thank you, sir. Can you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, Mr. Welday. Ms. Robertson, would you like to do the verification on this, or would you like me to?
No, I can do it. All right.
Great. Proceed
Ms.
well.
Mr. Welday, are the income and expenses reflected on the first annual account of trustee accurately represented?
Yes,
Have all of the interested parties been served?
yes,
Have you received any objections?
no,
All right, are you asking the court to approve the accounting today as prayed?
I am.
All right, thank you.
Good, yes, I'm just having a second look at the administrative expenses. It does appear everything is in order and accounted for, and the petition is also supported by verification of the investment accounts. So thank you for that. Mr. Weldy, it doesn't look like you were asking for compensation for the administration of this, is that right?
I am not.
Thank you. Appreciate that clarification. Okay, and Ms. Robertson, would you verify that the expenses that your firm is asking for would be considered legal expenses and billed at that particular rate rather than conservatorship duties?
Yes, that is correct. We represent the fiduciary, so all services rendered are legal services.
And you're confident that all of those services would be considered legal rather than conservator?
Yes.
Good. Yes, and I am looking at that itemized statement as well, and I would agree. Thank you for providing that. Or at least part of that. All right. The court finds all interested parties were given notice for purposes of today's hearing. I do find the fees and costs are reasonable and ought to be allowed. Not any exceptions, including that additional $317 as was itemized requested. So I'm signing approval. I don't have any written objections nor anyone else appearing to object either. So that's another reason that supports the granting of the request as proposed. The order has been signed. They can send it to you in the regular course of business. Unless there's any questions, that's all for today.
Thank you.
Thank you.